Okay, let's begin. It's noon. This is the info session for the Master of Science in Patent Law program on June 17th. My name is Chris Frank. I'm the director of this program. This will be recorded, so in case you're only able to make a portion of it, we'll be sending you the link afterwards to get the full presentation. To begin with, let me introduce myself. As I said, I'm the program director of the Master of Science in Patent Law program. We just completed our inaugural year at the University of Minnesota Law School, and we are now still recruiting for our second year beginning in the fall of 2015. A bit about my own background as it relates to patent law. I started out as an engineer at a company in Minneapolis here, 3M, that I'm sure most of you have heard of before, as a product test engineer. And this is where I got my first introduction to the world of patent law. I was actually comparing our product to a product of a competitor of ours. And it was my job to assess what features were superior or inferior between the two products. And as it turned out, the competitors had a much better product than ours. And so I thought, as an engineer, that this was my chance to develop the next great thing. But when I spoke to my boss about it, he kind of smirked and said, no, that's not what we're going to try to do here. What's going on is the competitor is suing someone else for patent infringement, and we are going to buy the winner. And that was my first introduction to patent law. So rather than innovate, we decided to purchase the company that owned the patents in this area for that product. And so I thought, as an engineer, I wanted to do something that was more engineering related and invent new products. So I moved to a startup company in town, Vascular Solutions. It was a medical device company. And there, it was a very exciting time. It's the late 90s, the tech boom. We went public, we got FDA approval, we started selling our products. And basically day one, when we first started selling our products, we got sued for patent infringement by another competitor. And so that, in 2 years as an engineer, I'd been at 2 companies and had 2 experiences in the field of patent law. And this made me realize that there must be something more to this patent thing. So I ended up going to law school and becoming a patent lawyer in private practice, where I represented inventors from large corporations to small startups in a garage, and got to just see a whole wide range of ideas and inventions and technologies. And from there, after doing that for a while in private practice, I became a patent portfolio manager at Medtronic. And so there would be 5 different products that the division that I was in had. Each product would have a couple of hundred new ideas each year, and we would evaluate each idea as to whether or not we should pursue patent protection on that idea. I did that for about 5 years, then just about a year and a half ago, joined this new program for the Master of Science in Patent Law, which was created for the specific purpose that there is a dire need for more people to enter this field of patent law, and there's simply not enough people going into this area, and that's why this program was created in the first place. So that's my background, and essentially the lesson learned from me beginning as an engineer and then in my career as a patent practitioner is that patents are the currency of innovation. And I can tell you, just from the point of view of a startup company, oftentimes what happens when a startup gets bought out by the larger company, they will look at the patent portfolio, because what they're really buying when they buy the startup company is the customers and the patents that go with that product. The people, the employees for the company, oftentimes don't want to work for a larger company. They'll just go to the next startup and that sort of thing. So it's the patent that allows them to transfer the technology to the purchasing company. Likewise, there are the large corporations that are engaged in all kinds of different patent transactions themselves, and we'll get into some more details of that later. But this is kind of the guiding motif behind how patents fit in with that whole world of science and discovery and innovation. Okay, so here's an overview of our Master of Science in Patent Law class, and it's based upon my experiences and the experience of many of our collaborators and practitioners in developing this program, we've kind of broken up the world of patents into 4 different categories here. So beginning at the bottom left corner, the first thing that happens is we have an innovation. Research and development comes up with the great idea, and then they move along to patent prosecution, which the name patent prosecution, what that refers to is the people who write patent applications. So a patent lawyer or a patent agent, something that you can be prepared to do in this program. Patent prosecution is a very misleading, it's a horrible name. It's really a person who writes patents. So you come up with the idea, and then you write a patent. That's patent prosecution. And then the next step is value extraction. You actually try to create money from that technology. And you can do it a few different ways. You can do it the old-fashioned way by manufacturing a product and selling it to people, or you can have patents on that technology and license those technologies to other companies that can monetize it. And then third, you can sue people for patent infringement and a whole bunch of different ways to make money in between. So that's kind of the simple view of the world. Come up with the idea, patent it, and then extract value from that idea. And then, to make matters more complicated, there is not a one-to-one ratio between an idea and a product. A single product, so for example, the original iPhone had over 2,000 patents behind it. And when I was a portfolio manager at Medtronic, we had 5 products, and each product had thousands of patents behind it on a different feature or a different material and so on. And so it's not a simple matter of one idea equals one product equals one patent. A single product has hundreds or thousands of ideas behind it, some patented and some not. And so we have to have this concept of portfolio management, of deciding which of these ideas to patent, why should we patent them, how should we patent them, and so on. And so that adds a whole nother new wrinkle to this concept of patent law. So that's kind of our overview of what the patent world looks like, how it overlays on your science and engineering activities. Now, specifically in developing this program, we of course wanted to make sure that the program teaches you the things you're going to need in order to practice in this area. So once again, following our same model, starting with innovation, we have a capstone innovation course where you literally will create and pitch a product, and you'll be able to choose your own technology or product area and come up with an innovation of your own and come up with a patent strategy and so on. So we're doing real world practical experience in this program. Next, you're going to take a patent prosecution course. It's actually a full year course, parts 1 and 2, where you will draft a patent application and draft other documents that are involved in gaining patent protection. So once again, real world experience. And then third, value extraction. We have an IP transactions, IP meaning intellectual property, transactions course where you will draft an actual licensing agreement. And then finally, you'll have a patent management class, patent portfolio management class, where you will look at the patent portfolio of an existing company and come up with a patent strategy as for how they can protect and grow their business using patents. So you literally are creating these documents and these reports and presentations just the same as you would in practice. Now, once again, using our exact same model and looking at the job opportunities that are out there, you'll see that they fit fairly closely with how we've modeled the program and modeled the types of work product that you'll be creating in the program. So in the innovation world, a number of our inaugural students have done some work with the startups. There's roles called technology managers, and they might just be called patent liaison or something like that. But the startups have tremendous value, and you can add tremendous value by understanding patents, is because you can do some of the science or engineering work along with the patent work at the startups, where it's often a common requirement that people wear many different hats. And so that's a very attractive area that is unique to graduates of this program, I think. And then we move into the next step, patent prosecution. So once again, that's about drafting patent applications for inventors. There are positions at law firms and at corporations for people that graduate from this program, where the job entails essentially drafting patent applications for new inventors. And then value extraction. For the most part, these roles are at universities, but some larger corporations are starting to move into this as well. It's the tech transfer agent positions, where your job would be to find people who want to license the technology that your organization has created. So the University of Minnesota here has a tech transfer office with, I believe, 20 or so tech transfer agents whose job it is to find external businesses that want to license university technology. And all universities that have federal research grant money are required to have a tech transfer office to try to commercialize those inventions. And so this is a job that's out there for people that maybe have more of that networking, kind of a marketing type of a personality. And then finally, patent portfolio management. That was a role that I did at Medtronic. Large corporations will have these roles called patent liaison or portfolio manager, where you're just making the decision, should we or should we not patent this idea? And depending on the company, the roles can differ. Some roles, they may include drafting the patent application yourself. Other roles, they may mean that you decide which law firm or which person to send the patent work out to, and you just manage that patent work from inside of your role as a portfolio manager. So as you can see, there's kind of 4 very different career opportunities all within the field of patent law, and I myself have been in 3 out of 4 of these roles. I've never been on the tech transfer side of things, I suppose, but it really opens the doors to a wide range of career opportunities that you can kind of pick and choose and create along the way. And so that's kind of the basis of this program, setting you up for the success. Okay, so a quick overview here, and then we'll get into some more details about patents and patent law, because it's been my experience in presenting this program. Most people don't know all that much about patents or patent law, so I'm going to give you a rundown of patent law in general. But first, let me just give you a quick overview of what we're going to talk about here as far as opportunities for you as a potential student. So we completed our inaugural class. We had 7 students in the first class, and they are getting jobs in the salary range of $70,000 to $80,000. In general, the #1 quote that I hear from people interested in this program is that I like science and technology, but I don't want to work in a lab. So going back to my own first job where I was doing product testing, putting things together and, one after another, doing hundreds of different tests, after a while, to some people can become boring. If you want to still work in this field, but you want to be able to see a lot of different ideas and technologies at the front end of things, it is a pretty cool career. Some advantages of this program: you're going to be taking classes from leading practitioners, from people that are really doing the innovation, the patent portfolio management, and the patent drafting in the real world for big companies, Fortune 500 companies, and so on. You're taking classes at a leading law school. The University of Minnesota has for a long time and continues to be a top 20 law school. You're taking classes with the other law students. So you're going to go out there on your resume having taken the exact same classes that the law students are taking. And actually, because this program has been set up for you to take all of the patent programs, for the most part, you'll have had more patent courses than practitioners out there. And in fact, that overview that I gave you with the 4 different boxes, most practitioners over about a 5 to 10 year career probably will not have seen all of the different types of projects that you will have experienced in 1 year in this program. So that's what makes it really, really valuable and unique. So you're creating this whole portfolio of work to show to potential employers. We are accepting applications for the fall, and we are offering $20,000 scholarships to people who are accepted into this program. And so if any of these benefits sound interesting to you, what we're going to do now is kind of give you a bigger, more detailed overview of patent law, how do patents work, what's it like to draft a patent application, that sort of thing, and where did this opportunity come from. So ready, here we go. Okay, first I want to show you is the growing need for patent professionals. And what I have here is a graph, opportunities in patent law. This fast rising light blue line shows you the number of new patent applications filed in the United States year over year. and you can see that it is rising very fast and is expected to continue to rise as companies realize how important patents are. As I said before, they are the currency of innovation. And then this bottom line, this flat dark blue line, is the number of new patent bar members, the number of new practitioners entering the field each year, and it has been flat, if not slowly shrinking. So therefore not keeping pace with the number of new patent applications. I call this an opportunity gap. There is an opportunity for new patent practitioners to enter this field because there simply aren't enough people entering to keep up with the demand. To back it up here, we have a recent study published in February that by 2018, the number of new entrants to the patent bar is expected to shrink to less than half of what it is today, or approximately 600 new patent attorneys per year. The 1,200 who entered in 2008 is kind of been the baseline. So the number is decreasing as the demand increases. This is an opportunity. That's why we've created this program. So now the question that we generally get with people is, don't I have to be a patent attorney? In other words, don't I have to go to 3 years of law school in order to work in the world of patents? And the surprising answer to most people is no, you do not have to go to 3 years of law school in order to work in the world of patents. You can become what is called a patent agent. And I'm going to compare patent attorney versus patent agent kind of throughout this presentation, but in general, a patent attorney must have a science and engineering degree plus a law degree, plus they have to pass the state bar exam to become a lawyer and the patent bar exam to become a patent lawyer. A patent agent, on the other hand, requires only the technical background, science and engineering background, plus they have to pass what's called the patent bar exam. It's a it's a 100 question multiple choice exam offered by the United States Patent and Trademark Office. If you pass that exam as a scientist or engineer, you can be a patent agent and you can represent clients just the same as a patent lawyer can and draft patent applications for them. Hold out you can literally hang up your own shingle and do that as a career if you so choose. So the question then is, how come I've never heard of a patent agent before? There's a few reasons. Number one, there used to be enough patent attorneys out there that there wasn't really that much of a need for patent agents. And then second of all, the patent agent position is something that usually a mid-career scientist or engineer would fall into or discover after 10 or 20 years into their career. And that was the case when I was a patent portfolio manager at Medtronic. My boss was an engineer with 20-some years of experience, and he had about 50 patents to his name as an inventor. And then he discovered that he could be a patent agent, and he passed the exam and became the patent portfolio manager for our division at Medtronic. So in general, it's been a kind of a secret career path for mid-career engineers and scientists. But because the demand is there and the supply is not, we have created this program to allow and try to educate scientists and engineers to choose this as an actual career path instead of it being something that is stumbled upon 10 or 20 years down the road. The opportunity is there. Okay, so there is some difference between a patent attorney and a patent agent. A patent attorney will focus more on the legal aspects of patent law, so they worry about the legal agreements. They can draft the contracts for the different parties and legal opinions about whether or not someone's infringing on a patent. And finally, and most importantly, litigation. You have to be an attorney in order to litigate in front of a judge and jury. A patent agent, on the other hand, is actually more of a business role, except for in terms of patent prosecution, which is that patent drafting role. A patent attorney and a patent agent are doing the exact same job. A patent agent is not an assistant to a patent attorney. They are doing the exact same job. I just want that to be clear. You're not an assistant. You can do the exact same job in patent prosecution. But a patent agent will be engaged more in the patent research side of things to decide if something is already out there, has already been patented. And then the portfolio management side of things is a business role. Should the business invest in getting a patent on an idea or not? And then finally, the innovation role. The patent agents are oftentimes more involved in the brainstorming sessions and technology protection and development from the business side of things. So, and we'll continue to differentiate as this presentation goes on. But in general, the patent attorney focuses on the legal issues. The patent agent focuses more on the business and technical issues. Okay, and just to show that there are jobs out there and kind of what these postings look like, here's one from Apple that it's about a year old, or a little over a year old, but just because everyone knows who Apple is. And this also kind of shows you how confused people are about this concept of a patent agent. Apple was looking for a patent agent. It's a patent technology analyst posting, and they had to be explicit here to say patent lawyers who prefer to focus on the technological aspects of patents rather than the practice of patent law will be considered, but this is a non-lawyer position. So look, Apple had to put that in there because even lawyers out there are confused about this concept of patent agent jobs and what a patent agent does, and that there are jobs that are looking for patent agents, not patent lawyers. And Apple being one of those companies looking for this type of person. Okay. And so here is just some random job postings that we're looking for patent agent roles, and you may or may not recognize some of these companies: Apple, Novartis Vaccines, Coca-Cola, Par Pharmaceutical, Avery Dennison, that's the paper label maker company, IBM, Glidwell Dental, Microsoft, etc. So a lot of different companies out there all looking for patent agents, not patent lawyers. And even though it's something that most people have never heard of, it is a career that's in high demand right now. And then here's a list. I'm sure you've never heard of these people, but the law firms out there that do a lot of patent law, and the different law firms will focus on different types of technologies. There will be a biotech, there will be a chemistry-focused one, and that sort of a thing. Okay, patent agent salaries. So this is some published salary data. It's a little bit misleading because, as I mentioned before, it's usually a mid-career switch that this salary data is based upon. So the patent agents are reporting here salaries in the $80,000 to $90,000 range. What we've seen with our students, now keeping in mind that none of them were mid-career professionals, they were all fresh out of undergrad before joining this program, but their salaries have been in the $70,000 to $80,000 range. Now, if you're someone with a few years of experience, then you probably can get more into that mid-80 to low 90s range, depending on your technology background and experience and so on. But these numbers are a good ballpark in what we've seen with our students as well. Okay, so this is the opportunity gap. It is real, and that's why we've created this program. So let's get into some patent law basics. I've probably given this talk to a couple hundred students, maybe probably more than that, 300 or 400 students over the last couple of years, and there's probably only been a handful of them that have even seen a patent before. So what I put into this talk, really, because if you're thinking about going into this program, you'll want to know a little bit about what the patent world looks like, what patent law really is, and that's kind of what the intention is of this portion of the talk. Kind of what is a patent? What's it take to get one? So patent law basics. Okay, so patents come from the United States Constitution, where we want to promote the progress of science and the useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. So essentially, the way to think about the patent system, the way it's intended to work, is that if you are an inventor, what I want as for the benefit of society, I want you to disclose to the rest of the world how to make and use your invention. And I want you to do that so that others can look at it and improve upon it and make further inventions and innovations. In exchange for you doing that, I'm going to give you a monopoly on your idea. So now, it doesn't necessarily mean it's worked out this way, but the intention is you disclose your idea, you get a monopoly, but now everyone else gets to see what it is that you did so they can improve upon it. So it is supposed to encourage further invention and innovation. Now, does it really work out that way is a debate that will be going on forever. It continues to go on to this day, but that is the intent behind it, to encourage innovation by disclosing how to make and use your idea. Okay, so with that in mind, to make sure that we're in the right room, the media will get this confused more often than not. When we talk about patent law, we're in the umbrella of intellectual property law. That includes copyrights, patents, trademarks, and also trade secrets. But when we talk about patents, we're talking about technological innovations. Media will sometimes say that, oh, so-and-so patented this catchphrase or patented this song. So that's not actually true. That's the incorrect use of these terms. Copyrights are what we use to protect artistic works of expression, such as a song or a screenplay or a novel, something like along those lines. Trademarks are what we use to protect business names and slogans, the Nike swoosh, the McDonald's golden arches, that sort of thing. Patents are what we use to protect the technological inventions that we are all talking about here. So just keeping that in mind, the media will get this wrong quite often, and the way that these different forms of protection work is very different. If you have an artistic work of expression, you don't have the same rights as you do if you have a patent. So what we're going to talk about today is a patent. What does that mean? And when we talk about patent law basics, there are essentially three requirements that it takes in order to get a patent. The idea must be useful, have utility, it must be novel or new, and it must be non-obvious. So these are kind of the three what we call legal hurdles that you have to be able to make in order to obtain patent protection. So I'm going to show you some kind of just fun and entertaining actual patents to kind of clarify what these different terms can mean. So the first question of an idea is it useful? Is it useful enough that it can be afforded patent protection? How useful does it have to be? Let's look at a couple of actual patents and decide for ourselves. Here's an actual patent issued in 1995 for a method of exercising a cat. So what we have is a person who has taken a laser pointer and they point it around the room and the cat chases after it. That is an actual patent that was somehow deemed useful enough to obtain patent protection by the Patent Office. Here's another, this is what I call the most cringeworthy patent ever. It is an apparatus for facilitating the birth of a child by centrifugal force. I don't want to go into too much explanation, but it is a giant machine that spins a person around in order to facilitate their birth. The only defense I can come up with for this is it came out in 1965, and we just, I guess, didn't know any better back then. But that is an actual patent. And just to erase that one from our memory, here's another patent that came out in June of 2013, a fantasy football system. Okay, so if we're looking at our first hurdle of patent protection, how useful does an idea have to be in order to be protected by a patent? It only has to be minimally useful for its intended purpose. When we talk about these requirements in terms of hurdles, it's a very low hurdle. So in fact, board games that you've played as a child or perhaps still play today, like Monopoly and Stratego and that sort of a thing, there is an entire unit in the Patent Office that will allow patents on board games like that. So as far as usefulness, it's not a huge requirement as long as it involves some sort of a technology. A board game is a technology enough to be afforded patent protection. So that's the first hurdle for getting patent protection. But that's not the only one. There's also the hurdle of newness. How new does your idea have to be to get patent protection? Do I have to make an incredible amount of change, or can it be very similar? Let's explore that. In our next example, we're going to talk about coffee cup sleeves. So back in 1993, this is all we had for coffee cup sleeve technologies. We had this corrugated cardboard with these kind of elongated grooves, let's call them. That was the technology in 1993. In the year 2000, somebody came along and thought that they had a better idea. Instead of these elongate grooves, they decided that dimples would be a better way to prevent your fingertips from burning when carrying your coffee cup around. And I've also pasted in that they have some kind of a heat transfer study that they put in their patent application and that sort of thing. So this was different enough from the previous coffee cup sleeve to be afforded patent protection in the year 2000. And let's go even farther into the closer to the present day. In the year 2013, someone came up with the brilliant idea that those coffee cup sleeves, it doesn't matter if you use grooves or corrugated cardboard, it's just such a thin material that your fingers are going to burn off anyway. So instead of trying to hold the sleeve, they put a tab at the top of the coffee cup sleeve so that you can use gravity to hold the coffee cup in your hand and you don't have to grasp it so tightly. And this was a new enough idea, a new enough improvement in this technology of coffee cup sleeves that it was granted patent protection in September of 2013. So how new does your idea have to be in order to be afforded patent protection? Any sliver of newness, anything that isn't already out there, no matter how seemingly trivial or tiny, is good enough from the point of view of this hurdle of novelty or newness. So that is our second hurdle in the world of patent protection. And here's our third and final hurdle. So the idea, it has to be useful, it has to be new, but last but not least, it has to be non-obvious. So you can't just take something that's made in the color red and change it to the color blue, or you can't just take something that is, 5 inches in diameter and make it 5.5 inches in diameter. In theory. So now the question becomes, obvious to who? So now this is where we talk about the field of patent law, and we start to have to talk like lawyers here. The question of non-obviousness is, would the idea have been obvious to a person of ordinary skill in the art at the time that the invention was made? And so first of all, we refer to in the patent world the technologies, we refer to them as art. So the art of coffee cup sleeves, and for whatever reason, that's how we refer to these technologies in this patent world. So what you're talking about in the patent world, you as a patent practitioner trying to protect an idea, you're going to have an argument with the patent office about this fictional, imaginary person of ordinary skill in the art and what they would or would not have thought was obvious at the time that an invention was made. So for example, we would argue with the patent office about whether or not it was obvious to add that tab to the coffee cup sleeve. And we would argue about what a person of ordinary skill in the art of coffee cup sleeves really knows about gravity and grip strength and air pockets and heat transfer and so on. And what's very even more confusing about this is a person of ordinary skill in the art, this fictional person, is deemed to not have access to any confidential information, and they are somehow deemed to not have very much creativity in putting things together. However, they are deemed to be essentially the world's fastest speed reader. They are deemed to have read every single patent and publication out there in the subject matter that the invention is in. So this is where patent practitioners, this is where you make your money. You spend your days arguing with the patent office about whether or not an idea is or is not obvious. And this is the type of argument upon which reasonable minds may disagree, as we say. So your job is to make the argument on behalf of your client that an idea is or is not obvious. Now let me give you my favorite illustration of all time to show you this principle of obviousness. So taking an invention that you're all familiar with, we have here the invention of rolling luggage. Back in 1972, somebody thought of this great idea. Why am I carrying this 50-pound bag around with my shoulders when I can use this invention called the wheel and just roll it right along, make it easy? So this invention was launched in 1972 and it failed. The reason it failed is they used tiny little pea-sized wheels, and they had a flexible handle, so when you turned the corner, it would tip over. If you went too fast, it would tip over. Essentially, it didn't work at all. As we all know, someone did eventually come along, and they turned the wheelbase 90 degrees, so they have a wider wheelbase. They used larger wheels for more stability, And also they created the extendable rigid handle, so when you turn the corner, it doesn't fall over. You have complete control over the suitcase itself. So when we're talking about this concept of obviousness, isn't that idea obvious in light of the previous idea? Here is my answer. It's not rocket science. Rocket science is easy. We landed on the moon in 1969. We perfected the wheel on luggage in 1989, 20 years later. And in between that first concept of luggage on wheels and the second concept of luggage on wheels, we had 4 billion people travel on the airlines and not come up with this idea. So in hindsight, a lot of things seem to us to be obvious that in fact were not obvious. And so as a patent practitioner, having to make this argument that something like the luggage on wheels invention is not obvious becomes an important job, because the fact of the matter is it changed the way that we carry our luggage. And it took us nearly 20 years to perfect that invention. So this is kind of the crux of the entire patent law experience, is understanding this concept of whether or not something is or is not obvious and being able to make that argument. Okay, so that's our patent law basics. You have to have something that's useful, new, and not obvious. And the usefulness and the novelty aspects are something that we all can essentially agree upon. There's not going to really be an argument about that. But when it comes to non-obvious, that is where reasonable minds may disagree, and your job is to make the right argument for your client. And that's why you will spend an entire year in the Master of Science in Patent Law program learning how to craft that argument. Okay, that's the patent law basics. Now I'm going to walk you through the actual patent process itself. So let's kind of put ourselves in the shoes of the inventor and say that you invented something. How do you go about protecting that invention? So I'm going to use a very simple patent here. It eventually becomes a patent. There is an invention of the stuffed crust pizza. And it was invented actually by an 18-year-old in New York, an Italian, of course. He was making a pizza for his girlfriend, and he folded over the outer crust and decided that it would be great if there was some kind of a food that could be stuffed in that outer crust. So let's kind of follow along in the patent process. So first of all, we had our 3 requirements. Pizza, is it useful? Sure, it's a food, arguably. It's a food, so that sounds useful enough. Is our idea new? That's the first question you're going to ask an inventor. Have you ever seen this idea before? And what we can do is a patent search. And at the time that this invention came out, this was the state of the art, as we would say. There was a kind of a pizza pocket looking pizza that was already out there, and then there was a donut shaped pizza. It's hollow in the center, but it's a pizza that's essentially the pizza ingredients are filled inside of basically a giant donut. So we would say it is new, it's novel enough. So those first 2 hurdles are cleared, and then we essentially can decide if we want to file the patent application, depending if we think that our idea is or is not obvious in light of what's already out there. And in this case, the inventor decided to go ahead and pursue patent protection. So here is the chance to file the patent application. So what does a patent application all actually look like? That's what I'm going to show you here. So if you end up in a role where you're drafting the applications, or if you're an inventor and you're the one coming up with ideas, this is what a patent application will look like. Essentially, you can look at the top right here. They first have a number of drawings. So what you have to do in your patent application, going back to what we saw, the constitutional requirement, you need to teach others how to make and use your invention. So in this case, it's literally a recipe. How do I make and use a stuffed crust cheese pizza? So we have drawings. There are literally people out there that make their living doing these patent drawings, which I've always thought was interesting. And then after these drawings, you have a description that tells you how to make and use it. And then at the very end of the patent application, this is the most important part of a patent application. They are what are called the patent claims. So when we talk about patent law and your rights under patent law, and we talk about patent litigation, what they are really talking about is the patent claims. Each claim is a single sentence that describes the invention that no one in the United States can make, use, or sell an invention that fits the description of these claims. So each claim essentially is a law. No one can make, use, or sell a pizza, a stuffed crust pizza that fits the language of this claim. And I'm going to show you what this claim looks like in a moment so you can see what's at stake here. But literally, when you're drafting a patent application, if you're going to spend, for example, 20 hours writing a patent application, you're going to spend 10 hours perfecting the language of the single sentence of a claim, and then you're going to spend the other 10 hours writing the rest of the document to support what it is that you have put in the language of the claim. Because the claim is what you're going to use if you're going to sue someone for infringement, or if you're going to license your idea, or if you're going to try to protect your idea. That's where the crux of patent protection comes into play. Okay, just kind of to visualize what claim drafting looks like, you take these two patents that are already out there, and if this green claim circle is, if you can imagine, that's what a sentence looks like, I'm going to draft it as broad as possible without going over the lines of what's already out there. And I'm going to stare at the ceiling, and I'm going to question myself. Should I call it an individual food portion or an enclosed stuffed portion? Should I call it a slice of pizza or a piece of pizza? Should I call it a food layer or a cheese layer? If I call it a cheese layer, then can somebody just copy my invention but not use cheese, and then they won't be infringing on my patent? All these thoughts are running through your mind as you try to draft these perfect patent claims. Okay? And then once you've done that, you've written your patent application, you file it with the United States Patent Office. You then have what is called patent pending status. So you don't have an actual patent awarded yet. You simply have notice from the Patent Office that your patent application has been received. And because we are dealing with a government entity here, you can have a patent pending for anywhere from 1 to 3 to 5 years before you hear anything back from the Patent Office. Once that happens, you'll get what's called a first office action. What they will do, they'll perform their own patent search, and they will either reject your patent claims or accept them. You can have more than one claim. Some may be rejected, some may be accepted, and so on. You then have a chance to amend your claims or make an argument that my idea is not obvious and I want to leave my claims as they are. And then they're on the clock. The second office action comes very soon after, usually within 90 days. And then you're going to have a patent that's actually allowed for your invention. Or it's not allowed and you can decide what to do after that. But essentially the end of it comes at the end of this second or final office action with the Patent Office. Now, once you have a patent, what does that get you? It gets you 20 years of protection from the date of filing. No one in the United States can make, use, or sell the claimed invention. Emphasis on the claimed invention. And here's what we claimed in our method of making a pizza. I've bolded the important parts of this patent claim because I think you're going to see where this is leading. So when they wrote the claim, which is protecting this invention, they required in the claim a plurality of separated individual food portions on the dough base. So let me put that in more plain English. Instead of having a continuous, uninterrupted cheese stuffed crust, they have a bunch of different little cheese crust stuffed portions. A plurality of separated individual food portions is how they say it there. So they don't have the continuous cheese crust. Do you see where this is going? In April 1987, this patent was allowed. In March 1995, Pizza Hut debuted the stuffed crust pizza, which is a continuous, uninterrupted stuffed crust pizza. It increased their sales by $300 million in the first year. Behind the scenes, the inventor of the patent that we just looked at actually approached Pizza Hut with his idea, and they turned him, depending on who you talk to, they turned him down or they offered him some small amount of money that he thought was not enough for his idea. He then turned around and sued Pizza Hut for a crazy number, $1 billion or something like that. And now, knowing what you know now about how to read patent claims, you can guess the outcome. He did not win. because his claimed invention was very specific in claiming a plurality of stuffed crust portions. I'll go back there. That's what he requires in his claim. That's the only thing that's protected by his patent. And so Pizza Hut essentially designed around his patent and therefore was not found to be infringing on it. So that's the day in the life of the patent drafting person. You stare at the ceiling and worry about every little word that you're going to write and how somebody is going to try to get around that. And it's kind of like a game or a puzzle in a sense, and it can be very, very intellectually interesting, to say the least. All right, so what I'm going to do now is kind of take you through a day in the life of these kind of different roles that are available to people interested in this field of patent law and kind of what that would entail. Sorry, I will jump back to this in a moment. So a day in the life. So patent prosecution, that's if you're the person drafting the patent application. So your inventor is the inventor of the pizza crust patent. You meet with the inventor. They tell you about their great idea. You do a patent search for them. You talk to them some more. You draft that patent application. You respond to the office actions at the patent office. And then there's other patent practice issues that you can be involved in. People will wonder if they can license inventions from other people and whether they might be infringing on someone else's patent and so on. But a day in the life patent prosecution, this is a role that you can take in a law firm, or you can do it also in-house at a large corporation. A lot of corporations have started to move towards, instead of hiring law firms to do the patent work, they hire a bunch of patent agents to work in-house and draft the patent applications there. So that's one of the roles available in this world of patent law. The other role that I talked briefly about before, patent portfolio management. This is a role where you're working more directly with all the scientists and engineers in a corporation. So for each idea that comes in, you're going to do patent research to find out what else is out there. Is your idea actually new or not? The joke that I had oftentimes at Medtronic, we would do a brainstorming session and we would come up with what we thought was a great idea. And then I would do a patent search and I would come back and I would say, well, I have good news and I have bad news. The bad news, this idea is already patented. The good news is it was us 10 years ago. So you will be amazed at what's out there already in the patent world and how many times the so-called wheel gets reinvented. Also part of Patent Portfolio Review Board, there's a Patent Portfolio Review Board. So you have at Medtronic, what we did every month, we would have a meeting with heads of marketing and technology and finance, and they would decide whether or not to file a patent for every single idea. We would review every idea to decide whether or not we should patent it. We would hold brainstorming sessions and come up with patent analysis and strategy. Now, how does this differ from a patent lawyer? So now, even though I am a patent lawyer by training, my patent portfolio position, I was a business person. I was looking at patents from the business point of view. There was a patent attorney at these same meetings because they were part of the legal group, which I was not part of. The patent attorney was worried about the legal aspects of our portfolio. For example, because we're a medical company, we had a lot of joint ventures with other medical companies. They had to worry about the legal aspects of inventorship and what responsibilities did we have if we invented something that was partially funded in a joint venture, or if we had government funding or funding from some other research-based entity. They were worried about the legal aspects, whereas I, as portfolio manager, and the group I was in, we had 2 patent agents and 2 patent attorneys that were in our group. It was all about the business aspect of patent law that we were focused on. Next one is value extraction. Talked briefly about this before. So technology transfer, you are looking at finding companies or organizations that would like to commercialize your technology. Larger companies are starting to get into this field, but mostly it's universities that do it right now. So this is a job for someone who's more of a marketing type of a person, a people person, going to trade shows, finding out what's going on in the pulse of the industry, evaluating the portfolios, and doing the due diligence. Now, once again, the patent agent role here is much different than the legal role. If you're the The tech transfer role, you're really trying to set up these deals with these companies, versus a person in a legal role is going to worry about the actual terms of the agreement. So for example, what if we are licensing it to technology this to company A, but they get bought out by a competitor? Then can we terminate the licensing agreement? Or what if someone is infringing on the patent that we are licensing out? Who's going to pay for the litigation costs? That's something that's going to be the legal aspect of a licensing agreement, and a patent attorney is going to worry about that. But you, as a tech transfer agent, are worried about getting this deal set up in the first place, not about the actual drafting of the legal aspects of the agreement. Okay, so that, let me go back actually to our, here we go, back to our curriculum. So here's what your curriculum will actually look like. Before the semester begins, we have a 2-week course, Intro to American Law, because you are taking actual law school courses at a top 20 law school. We have a 2-week crash course in how to take a course in law school. It is drastically different than what you've had in your engineering or science courses, and the students found this incredibly helpful to prepare them as they joined into the law school courses. So that 2-week course kind of introduces you to how to read a case, how to look at it, how to make kind of legal arguments and that sort of thing. And then in the fall semester, you'll have a patent law course where you're reading the Supreme Court decisions. So for example, the Supreme Court just came up with a case about whether or not software should be allowed to be patented. And you'll read these cases and come up with some sort of an interpretation about what that exactly means. Patent prosecution is where you learn how to draft patent applications and that whole process that we went over with our pizza patent. Portfolio management, you literally will create a portfolio strategy for an existing company. Writing analysis and persuasion, this is a master's only class. This is where we will be teaching you kind of the finer art of drafting legal arguments. As we talked about before, how to argue that something is or is not obvious is going to be a major part of that. But in this writing course, it's not going to focus on patent law, it's focusing more on just your writing skills. And so in fact, one thing that was very valuable in that course, we had the students draft the cover letter for their resume and also their informational interview cover letter, so that they had something practical that they were creating as a part of that writing course. Patent Pro Seminar, we have different patent practitioners come in each week and talk about their roles in their companies and law firms and that sort of a thing. You'll have people from General Mills and 3M and Medtronic and so on talk about their experiences in patent law and startups and small companies and so on. And then also we have a number of elective courses that you can take. Not all of them are listed here, but patent research, litigation, copyrights, trademarks. A lot of students ended up taking as an elective food and drug law course, because that actually plays in to a lot of the patent work that goes on, especially here in Minneapolis. In the spring semester, you'll have the Patent Prosecution Part 2 course, the Capstone Innovation course where you come up with and pitch your own idea, Patent Transactions course where you will draft a licensing agreement, another Patent Pro Seminar course where you continue to network with professionals in this field, Ethics for Patent Agents. You'll discover when you start working in this field that when you tell people that you work with inventors and you help protect their ideas with patents, that everybody has some sort of invention, and you need to know what to say to these people to keep them and yourself out of trouble, I guess. So we have an Ethics for Patent Agents course that I think is an important part of this program. And then spring semester, there's 1 or 2 electives. Actually, a lot of our students, the first year, they took the International Patents course and also the Advanced Patent Law course. And then you have a fall and a spring semester, but you're not done yet. As I mentioned at the beginning of this presentation, there's the patent bar exam at the U.S. Patent and Trademark Office. It is a very difficult exam. It has something like a 30% pass rate historically. However, if you take a patent bar review course, the pass rate goes up to 90%. So we include, as part of your tuition, the patent bar review course that it's a company from New York that will come on site and offer you the patent bar review course to give you that 90% chance of passing that exam. So that, I think that's a great benefit. If you were to do that on your own, the patent bar review course by itself costs $2,000, and that's not counting, it's a 5-day course. You would have to get hotel and flight. They generally don't, this is the first time they've ever, this year is the first time they've ever offered it in Minneapolis. We had quite a turnout, not only from our students, but from other professionals in the Minneapolis area. But before us coming along here, you would have had to fly to either Chicago or New York or LA to take this course. So having this included in your tuition, if I spend the time to show you the math, it's another couple $1,000 savings benefit that you're getting, or additional benefit that you get as part of this program. Okay, so that's kind of our overview of the program. Are we taking applications for fall 2015? Yes, we are. So, as I mentioned, our first year we had 7 students. Getting the word out about this program has been the biggest challenge, because the demand is there, but we just are having a hard time finding the people. We are looking for you for fall 2015 if this sounds like something you'd be interested in, and we are offering a $20,000 scholarship. Who's the program for? If you like science and technology but don't want to work in a lab, if you're considering law school but don't want to invest 3 years, and if you want a 1-year professional master's degree, getting a master's degree in 1 year, and it prepares you for this career that, as you saw, you have a whole different array of career options that otherwise probably would not be available to you. So it's a great program, and our inaugural students have had great success in their careers. One comment: if you are considering law school, the one disadvantage, if you eventually plan to go to law school, transfers, credits do not transfer into law school. You can't transfer any credits into a law school if you weren't accepted into the law school program before taking those credits. So it doesn't help you as far as shortening your law school if that's your goal. Okay, anyways, who is our ideal candidate? They have the interest and capacity for learning a wide range of new technologies, strong technical writing skills or an interest in developing those skills, strong analytical abilities or an interest in developing those abilities. And really, if you're interested in this program, feel free to give me a call and set up a meeting. We can discuss kind of what your background is, what you're interested in. There's a lot of great benefits here. You're taking the patent law courses with JD students, learning from leading practitioners at a top 20 law school, getting these practical skills. As I showed you at the beginning here, you're creating this literal portfolio of work, and you're getting exposure to these things that most practitioners won't see in 5 or 10 years of practice. You're getting that all in 1 year. And you're taking the patent bar exam as well. How to apply? We need a statement of interest, a letter of reference, transcripts, and a resume. GRE or LSAT scores are optional, they're not required. And if you have any questions or want to set up an interview with me, I'm happy to speak with you. Send me an email or give me a call. And that is the end of the presentation. This is recorded, and I will post the link to you as soon as it's available. I think it usually takes about 30 minutes to show up. And feel free to shoot me any questions, and let me see if I have any questions showing up. I don't. So thank you very much for your time, and I hope to hear from you. Thank you.